Good morning, I'm Gary DeWaal, and this is Bridging the Week for March 6th to 10th, and today is March 13th, 2017. A non-U.S. entity was accused by the Securities and Exchange Commission of engaging in manipulative trading through layering and cross-market manipulation involving stocks and corresponding options. Perhaps more significantly, the entity's carrying broker-dealer was also accused of facilitating its customers' illicit activities by ignoring repeated alerts of its clients' wrongdoing by regulators, exchanges, and other market participants. Additionally, a U.S. appeals court ruled that Dodd-Frank's anti-retaliation protections for whistleblowers protects employees of public companies that report security law violations internally and not just to the Securities and Exchange Commission. This week is the annual FIA Industries Conference in Boca Raton, Florida that I am attending. So I can scurry about and find any interesting developments to report on next week. Let's get started. Leck Securities Corporation, a U.S. registered broker-dealer, and Samuel Leck, its 70% owner and chief executive officer, were sued by the Securities and Exchange Commission for facilitating manipulative trading activity by its customer, Avalon FA Ltd., a non-U.S. entity, and its two control persons, Nathan Fayer and Serge Pastulanik. According to the SEC's complaint, filed in a federal court in New York City, Avalon engaged in two types of manipulative conduct: layering and cross-market manipulation involving securities and related options from December 2010 through at least September 2016. In its complaint, the SEC charged that Leck and Mr. Leck were aware of Avalon's improper activities when, among other things, they received an explicit email in May 2012 explicitly describing the layering scheme from an individual who shortly afterwards became an Avalon Trade Group leader, as well as when regulators, exchanges, and other market participants alerted Leck and Mr. Leck on various occasions during the relevant time period that they were concerned that Avalon was engaging in layering. Among other remedies, the SEC seeks injunctions, disgorgement, and fines against each of the defendants. As the SEC's action against Leck and Mr. Leck, as well as the Commodity Futures Trading Commission's recent enforcement action against Advantage Futures LLC and two of its principals demonstrates, neither the SEC nor the CFTC appear hesitant to bring an enforcement action against a registrant if the registrant fails to take what the regulators consider to be responsible, appropriate action in the face of well-supported allegations of wrongdoing by a customer. A federal appeals court in San Francisco ruled that anti-retaliation provisions under whistleblower rules of the Securities and Exchange Commission protected an employee, Paul Somers, who reported possible securities law violations to his company's senior management and not to the SEC. Mr. Somers' employer, Digital Realty Trust, Inc., had argued that because of conflicting federal laws, the Sarbanes-Oxley Act of 2002 and the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, such anti-retaliation protections only existed for employees of public companies who reported potential violations internally as well as to the SEC. The court rejected this view. Mr. Somers was fired by his employer after making reports of wrongdoing to management. He then sued his employer in a federal district court under the anti-retaliation provision of the SEC rules adopted pursuant to Dodd-Frank. In response, Digital Trust filed a motion to dismiss, saying that Mr. Somers was not a whistleblower under Dodd-Frank. Mr. Somers opposed this motion, prevailed in his argument, and the federal appeals court in San Francisco, namely the Ninth Circuit, upheld the district court's decision. One other federal appeals court in New York, the Second Circuit, has ruled similarly as the Ninth Circuit, while another in New Orleans, the Fifth Circuit, has ruled contrary-wise. Let's see how this all plays out. For the second week in a row, a panel of the Hearings Committee of the National Futures Association banned a firm and an individual principal and associated person of the firm from NFA membership for not cooperating with NFA staff during an investigation. Specifically, last week, the panel held that Sumiko Worldwide Markets, a registered commodity trading advisor, and Thomas Gasparini, a principal and AP of the firm, failed to cooperate with NFA staff when they failed to produce bank account statements and written explanations for certain transactions as requested during an examination of Sumiko during December 2015. 2 weeks ago, Next Capital Management, also registered CTA, and Jacob Wall, an associated person and principal in Next Capital, were permanently barred from being members of the NFA or from acting as principals of an NFA member for likewise failing to cooperate with an NFA examination. And finally, the Financial Industry Regulatory Authority proposed a sweeping overhaul of its requirements regarding qualification examinations. Currently, only persons specifically sponsored by a FINRA regulated firm may take qualification examinations. FINRA proposes to modify this requirement and offer a quote-unquote securities industry essentials examination to anyone seeking to enter the securities industry, whether associated with a member firm or not. FINRA is also proposing some relief to accommodate persons who have passed qualified examinations but move to affiliated companies and don't return until after more than 2 years. Currently, such persons would have to retake their qualification examinations after returning. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, when I return from Boca Raton, Florida, ciao.